All right, let's come back to the eastern part of the country, to PG County in Maryland. Another issue with employee-owned cell phones, and this is the text chain, right? The dreaded text chain. No one likes these things. So we have a use of force, right? We have an officer, a bad actor officer, okay? And not only do we have a problematic use of force, we have an officer who's using his personal cell phone, taking pictures. Hey, this is cool, right? Videoing it, whatever he was doing. We know you can't do that, right? We also know that, it has happened. Hopefully it doesn't happen so much anymore. But this guy's doing that stuff. Other officers on scene report him and say, hey, that's not good. Can't do it. The police department, conducts an investigation, right? And it conducts a, criminal investigation. And as part of that investigation, they sought and they obtained a warrant to get Officer W's cell phone and to search its contents. Okay, great, right? They get a warrant, they get his personal cell phone. What were we just talking about with Toriano, right? That's what we should tell them. Get a warrant. You want this phone, get a warrant. Well, in PG County, they got a warrant, they got the cell phone. So why are we talking about it? We're not talking about Officer W, right? Because when they get the cell phone, right, with the warrant, they search the cell phone and they see a text chain. And the text chain has got a bunch of racist crap on it, mostly coming from a different officer, this guy, Officer B, right? That's what the case is about. The department then initiates charges against Officer B, and Officer B says, sues, right, to halt the discipline. And says, this is a private, text chain that I have, right? You can't, discipline me for that, right? That's going to violate my speech rights. I have every right to text whatever stupid bullshit I want to text to other people I work with, right? Racist though it may be. Not so fast. The officer was successful actually at trial court. And there's a test, right? When we are weighing the First Amendment rights of public employees, we don't need to go through all of the factors of that test. But one of the factors is, are we talking about a matter of public concern? And the lower court said, sure, private texts, a 16-person racist private text chain among police officers, yeah, that's a matter of public concern. And that was part of the basis the court used to actually provide protection to this officer. On appeal, the appeal court instructed that was wrong. The public concern standard was misapplied by the lower court, and that's correct. And so what the court stated in that particular case was that, this use of public concern, right? And courts have a tough time with this. It means that the subject matter of the speech, objectively pertains to public welfare rather than just private interest or viewpoints. And so, while, yeah, the fact of a police officer sending racist text messages might cause public concern, that wasn't the subject matter of the text. This was personal BS. And that's not a matter of public concern. There's no First Amendment rights that attach to that particular case. And so different standard, right? No privacy afforded to Officer B with respect to those, what he thought were private text messages, right? So be careful when you're saying, you know what, how about not be a racist and how about not send racist text messages? Good advice there. But just be careful, right? If you're texting a coworker, there may be circumstances in which, those texts are going to live on and they may be accessed by the department in a lawful manner, right? And that's what happened to Officer B. When the employer owns the cell phone, right? The employer is going to have a more access to information, right? A greater right to access information, but it's not, going to be unlimited. There's a case out of Alabama, the Pelham case, City of Pelham case from 2021, that we still talk about. And this is, hey, be careful. We got a personal cell phone, plugs it into the work computer because she thought she was charging the phone, right? She was not charging the phone. Well, she actually was charging the phone, but there was an automatic upload. So all the images on her phone got uploaded into the work system, including nude photographs of her with other people, right? That's the Southwest Airlines, you want to get away moment, right? That was the want to get away moment. And the employer, it causes a fuss, as you might imagine. The employer investigates, and ultimately they fired the officer for that conduct. The officer argued that you can't fire me on the basis of these private, pictures that I have on my private cell phone. The court said, well, that's right, until you uploaded those private photos onto our work computer. The privacy ends there, and the officer was not successful. Kind of a flip side of that case, and a recent case out of Wisconsin that we reported on. And this has to do with access to a Dropbox, right? And so we all know what Dropbox is and Dropbox accounts are. We had a detective who was taking work files and uploading them to a private Dropbox account. Now, that's not involved in the case necessarily, whether that was legal or not. But the search was an issue there. And the question was whether or not this officer had a privacy interest in the Dropbox account, right? So the officer actually accessed the Dropbox account on a work computer, right? And used a work email, I think, to start it. But the court says by using a password that's not shared, right? These cloud storage accounts remain private unless you're sharing files with others in the department. So it's essentially the equivalent of a locked file cabinet, right? A file share, so long as it's password protected. And so there was a reasonable expectation of privacy there. Very interesting case. Not sure if that standard is going to hold up. But, hey, we just tell you about the cases. So, what does this all mean with respect to cell phones? The